सॉरी ऑनलाइन चेक करो तो ऑनलाइन चेक करो ना
door. And wherever you do find empty seats, I request you to please occupy them. We will be beginning. We will be starting shortly. Ladies and gentlemen, good evening. It's my honor and privilege on behalf of Mobius Foundation to welcome our chief guest and program chair for today's dialogue, Honorable Mr. Justice Prakash Srivastav, Chairperson of the National Green Tribunal. Welcome, sir. So we're very grateful for your presence and leading today's important conversation. Thank you, sir. So good evening again, ladies and gentlemen. A very warm welcome to all of you. So on behalf of the Mobius Foundation, it gives me immense pleasure to welcome you to this dialogue on the International Court of Justice's advisory opinion on climate change here at the Bharat Mandapam. So many of you know the ICJ's advisory opinion delivered earlier this year on the 23rd of July is a landmark in international law. For the first time, the court affirmed that states have legal obligations to prevent and mitigate climate harm and what legal consequences would arise when states because of their acts or omissions cause climate harm. This opinion comes at a time when climate litigation is accelerating worldwide, from European and Latin American courts to youth-led petitions across Asia and the Pacific. So today's dialogue is about exploring what that means for India, for international law, and for the future of climate governance. It is a privilege to have with us some of the most distinguished voices on the subject. Our special guest, our chief guest, uh, Honorable Mr. Justice Prakash Srivastav ji, who will be leading the chair. We also are very privileged to share this dialogue with Honorable Justice Antonio H. Benjamin, the Chief Justice of Brazil's National Court, through a special video message exclusively for this occasion. I would also like to extend a very warm welcome to our esteemed guest from the Brazilian Embassy, His Excellency Ambassador Kenneth Nobrega. Welcome, sir. Your presence underscores the international solidarity that this dialogue represents. So joining us on stage this evening are three eminent voices who will help us unpack what the ICJ's opinion means in practical, legal, and societal terms. So may I please invite Mr. Jatinder Chima, advocate, barrister, solicitor, and author. Welcome, sir. Ms. Urmi Goswami, senior journalist with the Economic Times, whose work has made climate policy and governance more accessible to the public. Welcome, ma'am. Professor Narendra Singh, former head of Legal and Treaties, Ministry of External Affairs, and member of the International Law Commission. Welcome, sir. And I finally would like to extend a very warm welcome to our youth present here this evening. Professors and students from law colleges across Delhi, including Symbiosis Law School, Amity Law School. We also have students from Kirori College, Miranda House, Terry, and other colleges under Delhi University, as well as students of environmental sciences and sustainability. So together, we will not simply restate what the ICJ has said, but we will explore what it means, what happens next, and how law policy and public opinion might intersect in the years to come. So to set the tone for this evening's dialogue, I would request our chairman, Mr. Berman of the Mobius Foundation, to please deliver the opening address.
Learned speakers on the dais, ladies and gentlemen, I think this is the most important opinion ever on climate change and on sustainability. What it means is that anybody, I think if we think of ourselves, anyone, any entity can sue India for causing damage due to overproducing the carbon dioxide which leads to climate change. So be careful. We might be in trouble tomorrow if we don't do something now. The world today faces an existential challenge: climate change. Recent research warns that our cumulative impact on the oceans, already substantial, will double by 2050, just 25 years from now. Scientists caution that such impacts may exceed the capacity of ecosystems to adapt. Coastal regions where most human activity occurs will bear the biggest burden. The alarming reality is part of a wider crisis of environmental hazards. In response, the UN General Assembly, together with small island states, sought guidance from the court delivered this landmark advisory opinion describing climate change as an existential threat. This opinion is the most significant development in the international climate law since the Paris Agreement. The ICJ clarified states' obligations under international law and outlined the consequences of failing to act. In doing so, it has firmly established climate justice as a matter of legal duty, not voluntary goodwill. So the question before us, judiciary, policymakers, lawyers, activists, and citizens is simple. Where do we go from here? The answer lies in climate action. What does climate action mean? At its core, it's a political, economic, and legal enterprise. Politically, it redefines our relationship with both the state and nature, demanding decision-making that is participatory, equitable, and inclusive. Economically, it is about just transition, shifting to renewable energy, integrating sustainability into infrastructure, and managing natural sources responsibly. For developing countries, the challenge is acute. How to advance a clean transition while ensuring social and economic well-being. Achieving this balance requires embedding international obligations into national laws, strengthening enforcement, and scaling up finance and adoption support. One of the most striking trends is the rise of climate litigation. By 2024, nearly 3,000 cases had been filed across 60 countries. Litigation in the global south, in particular, is expanding rapidly. Nearly 60% of all recorded cases have been filed since 2020. In 2024 alone, 56% of new cases were initiated by government bodies, signaling a decisive shift towards enforcement actions and claims for compensation for local climate damages. The ICJ opinion strengthens this trajectory. It moves us from voluntary pledges to enforceable obligations, reshaping the legal landscape of international environment law and paving the way for greater accountability. What is the course India is obliged to take in view of the advisory must take precedence over development? We have alternatives. The sun, plenty of sunshine, biogas from gobar. We have the largest number of cattle in the world, wind energy, without blades, which does not endanger birds, and green hydrogen. These are the various ways we can mitigate the actions of climate change. Number two, reduce the use of oil and coal from power to zero in 5 years. That will be doing something. It is possible to do this if we do it in a mission mode. Thank you.
Thank you, sir. A very relevant and insightful message. So what really stands out and reiterates once again is that the ICJ advisory opinion is not just a legal milestone, but a call to action. So now we will listen to the very special video message from the Honorable Justice Antonio H. Benjamin. May I please request the technical team to please play the video message?
Let me begin thanking the organizers for the invitation. It's always a pleasure to participate in events with the colleagues from India. Some of you probably know that I have a close relationship with India, many friends, and particularly with the ambassador of Brazil in New Delhi, His Excellency Kenneth Nóbrega. It's always a pleasure too to participate in events and discussion with my dear colleague Prakash Shrivastava, the presiding judge or the chairperson or the Chief Justice of the National Green Tribunal of India. The topic of this event, advocating change from climate justice to climate action, has different perspectives, as you could expect. First, it is relevant to say that often it's not from climate justice to climate action. It's from climate action to climate justice, because climate justice is not something that comes directly from heaven. It is something that is achieved through different avenues, one avenue being, of course, litigation. And this discussion is brought here today in the context of the International Court of Justice advisory opinion, quite recent and still being read and debated. I think it would be necessary to start our conversation just reminding ourselves that what we have in front of us is an advisory opinion. But the term advisory here is much stronger in real life than what the terminology would indicate. Because when the International Court of Justice speaks about something, spells out doctrines, highlights principles, identify existential threats, all this is much more than in the level of an advisory context. In other words, it's the power of persuasion that comes with such an advisory opinion. The other aspect in the outset that I would like to allude to is the fact that the opinion is much more relevant in the dialogue with courts in national context, subnational context. So Supreme Courts of different countries, regional courts, or even local courts. It's not so much an opinion, and this is pretty obvious, and you all know this, that decides a particular issue that is in front of the court, but it gives a sort of roadmap that strongly recommends different paths that courts, and especially as judges dealing with climate cases, should or could follow. But to me, the most important impact or quality, if you will, of the opinion is to bring together in a single document everything that we have been saying in a cacophony of voices all over the world. All that is brought in an organized format, quite presentable, with a systematic approach that can, and I'm sure it will, illuminate the work of judges globally when we decide climate cases. From a national perspective, and this applies to India and to Brazil, now we use my last 5 minutes for this comparative analysis between the two countries. We, of course, can learn from the advisory opinion, but both countries, very strong, solid democracies with a robust system of legal norms protecting the environment and courts, independent courts. For the two countries, the advisory opinion will have an impact because we'll decide it, but we in India and in Brazil already adopt many of those points, paradigms that are indicated in the advisory opinion. At the level of the principles, there is nothing that is said there that is not already part of the environmental and climate jurisprudence of India and Brazil. It's true that the two countries, particularly in respect to climate change, still are not exactly on the same page, but in environmental law in general, we are. In terms of the protection of the elements of the environment, wildlife, and this holistic perspective of the way we see the environment in our countries, this is pretty much already settled in India and Brazil. In the case of Brazil, this understanding of the environment as a single entity composed of elements is something that is sort of artificial. It had to be created by law, because before 1981, when our National Environmental Policy Act was enacted, before that we had forest, we have water, we have pollution, and different legislation dealing with those issues. It was not in our mind that a problem with the forest, deforestation, for example, could, in a domino effect, affect all the other elements. The same with air pollution or water and so on. But in India, this is part of the legal system, but it's more than that because it's part of the ethos of the Indian people with a very strong ethical background that is part of the way of life and of course with a strong input from Hinduism. But again, if we forget that aspect, which somehow historically makes us different, the two systems are very, very similar. And I end with a similarity that to me is the most powerful in respect to making sure that this advisory opinion will have concrete repercussions, is the fact that the two countries have established judicial system that hears environmental cases and climate cases in a quite independent manner. And both countries have specialized courts. In the case of India, the National Green Tribunal. In Brazil, special benches in both the federal system and the state system. Without courts and strong courts, independent courts, and courts with knowledge about climate and the triple environmental crisis, we would not go very far. It's not that judges or courts will solve the climate problem. This existential threat and dilemma that humanity faces, or the environmental crisis. But it's also true that without judges, we would probably not go very far. Many thanks again for the invitation, and I regret that I'm not there in person.
Yeah, a very powerful and insightful message. And I think he reiterates to us that law can really be a tool for transformation. And the ICJ's advisory opinion can be looked at as sort of magnum opus, a very seminal work for climate litigation in the foreseeable future. So without further ado, I would like to invite our first speaker, Mr. Jitendra Chima, to please share his remarks on the advisory opinion. So you may sit there. You sure?
Honorable Mr. Justice Prakash Srivastava, Chairperson of the National Green Tribunal, Honorable Chief Justice Benjamin, Chief Justice of the Supreme Court of Justice, Brazil, Professor Narinder Singh, Dr. Burman from the Mobius Foundation, Urmi Goswami, Ambassador Nobrega, very warm welcome to all of you. Dear members of the bar, my colleagues from the bar, students and friends. I think a big constituency of students have come this evening, and I'm most grateful to you because you are the real hope for India. So a big round of applause for all of you. It's interesting that this dialogue is happening at the angle of the COP30 at Belém in Brazil. Ambassador, I chose to wear the Brazilian colors today. You know, there was a debate this morning with my wife as to what tie I must wear. I said, must choose a tie which has Brazilian colors of its flag. So here I am in support of the event that is going to unfold in Belém in November. I thought I'll do an introductory kind of speech to set the stage for the debate this evening. On 23rd July 2025, when the International Court of Justice issued an advisory opinion, it can be described as a constitutional moment for international law. For the first time, the court was asked to speak directly on the obligation of states in relation to climate change. And in doing so, it transformed climate governance from voluntary politics with binding law. The court posed two essential questions. What are the obligations of states under international law to ensure protection of climate systems and other environment for present and future generations? What are the legal, number two, what are the legal consequences under these obligations for states where they, by their acts or omissions, have caused significant harm to the climate system? These questions were not theoretical. Behind them stood sinking islands, displaced communities, and generations whose world is being reshaped beyond recognition. What makes this opinion transformative is not only its answers, but way it reframed international climate law. The Paris agreements, once dismissed as a soft framework, of cooperation was reread by the court as a treaty embedded in customary law. Nationally determined contributions, it held, were no longer aspirational gestures. It is an enforceable expression of each state's highest possible ambition, grounded in best available science and in light of equity. Equal adaptation was redefined. Court reminded us that planning for floods, droughts, and sea level rise is not benevolence anymore for states which are governed by governments. It is a legal responsibility. Developed countries too were reminded that climate finance and technology transfer were not an optional charity, which it has been so far. They are binding obligations. Yet the court did not stop at treaties. It looked deeper into customary international law and found a legal framework binding on all states, whether or not they are party to the Paris Agreement. The no harm rule was reaffirmed as a cardinal norm. The duty of due diligence of each state was elevated, demanding constant adaptation of policies to evolving science. Environmental impact assessments were cast as universal procedural duties, and the duty to cooperate in good faith was stressed, underlining the collective nature of this crisis. In doing so, the court universalized climate obligations, making it clear that no state may stand outside the law. Perhaps the most striking innovation was the integration of human rights in this judgment. The court explicitly recognized that climate change undermines rights to life, health, food, water, housing, and adequate standard of living. Most groundbreaking was its affirmation, and I quote, "The right to a clean, healthy, and sustainable environment has sustained the status of customary international law." Here, the opinion elevated morality into law. States now have a duty not only to its own people, but also to indigenous communities, children, elderly women, and those displaced by climate collapse. And in a profound jurisprudential move, the court declared that duties are owed not only to present generations, but to future ones as well. Intergenerational equity, long whispered in academic debates, has entered the language of a binding law. This reminds us that states must act decisively on climate obligations, not for praise or political gain, but because it is their duty to protect life on Earth. The court reaffirmed the precautionary principle. As the Chief Justice from Brazil has mentioned, Indian jurisprudence has been quite robust in terms of enunciating principles in the environmental law space. It is now going to unravel how this jurisprudence is going to be used in the climate space. I think most people confuse environment with climate law. There are two different, completely different subjects. And I think that's a very, very important distinction that needs to be made. Climate law stands alone based on science, and because of the carbon footprint of human beings like you and me. So court has affirmed that the precautionary principle that scientific uncertainty is no excuse for inaction, and the polluter pays principle holding that those who profit from pollution must bear its cost. But here the opinion exposed the tensions. The court recognized the polluter pays principle, but stopped short of fully incorporating it into a binding law. Judge from India, Justice Bhandari, in his separate opinion, has criticized this restraint of the court, arguing that accountability requires concrete mechanisms, claims, commissions, compensation funds, restoration of maritime entitlements for submerged states. A very, very profound statement, and I'm sure the Pacific Island states are going to use this separate opinion of Justice Bhandari to argue its matters before, when it brings cases and litigation before national courts across the world. This divergence is telling. It reveals the space between declaratory principles and operational justice. It is here, I submit, that the next wave of reform must emerge. Another nuance from this opinion is its treatment of lex specialis. The court acknowledged that the climate treaties like Paris Agreement are specialized regimes, but insisted that they do not displace general international law principles. Instead, they must breed in harmony with human rights law, the law of sea, the law of state responsibility. This interpretive choice prevents climate law from becoming a silo. It binds climate governance into fabric of wider legal order, a recognition that planetary crisis cannot be compartmentalized. The court was unequivocal, and I quote, "A breach by a state constitutes an internationally wrongful act entailing responsibility of that state. The responsible state is under continuing duty to seize the wrongful act and to provide assurances of non-repetition and make full reparation. Wrongdoings, the court reminded us, is not extinguished by collective nature of climate harm. Accountability extends not only to state actions, but to failures to regulate private actors. A very, very profound observation of the ICJ judgment. Horizontal effect of climate law, not only between the state and the citizen, but also the horizontal effect between individuals and individual rights. States may now be held responsible for emissions, subsidies, and toleration of polluting industries. And I think I will just take a few more minutes to put together what is not in the ICJ opinion. While it has been hailed as a new era of climate reparations, the advisory opinion avoided addressing how colonial histories continue to shape our present day. Climate injustices and need to decolonize international law. Despite these important pronouncements, ICJ was evasive about the temporal aspects relevant both to the existence of customary obligations and their breach. In discussing the temporal scope of the request for an advisory opinion, ICJ identified that issues of temporality were relevant to both questions: A, about obligations of state to protect the climate system, as well as B, about the legal consequences for breach of these obligations. With regard to question A, the ICJ acknowledged there was unresolved, highly contested question as to when there was crystallization and identification of obligations for states to protect the climate system. This is para 97 of the judgment. The identification of this moment of crystallization has important legal implications for question B, given the requirement that the international obligations enforce when conduct allegedly leading to a breach occurred. Additionally, ICJ acknowledged the related temporal question as to where was a sufficient scientific understanding of the causes of climate change and its adverse effects to give rise to foreseeability of harm. I think these are all principles that students and lawyers like us have studied, and we use them all the time in the court. To give rise to foreseeability of harm and thus obligations under customary international law. The ICJ declined to opine on these temporal questions. Instead, it observed while these temporal issues may be particularly relevant for a concreto assessment of the responsibility of states for breaches of obligations pertaining to protection of climate system, the present opinion is not concerned with invocation and determination of responsibility of individual states or groups. I will skip a few pages and I'll come to my final conclusions. There are three pillars which are part of this ICJ opinion, which creates a legacy for the ICJ. And this is in paragraph 426, where the court has crystallized its contribution into three pillars. One, confirmation of binding principles such as no harm rule, due diligence, precaution, and polluter prey principles. Two, clarification of attribution extending responsibility to omissions and failures to regulate. This is particularly relevant for states. Recognition that breaches constitute internationally wrongful act with consequences under state responsibility. Together, these pillars dismantle the age of climate, what I call climate voluntarism, and replace it with the law of obligation. In conclusion, Excellencies, this advisory opinion is more than jurisprudence. It is both a mirror and a warning. A mirror reflecting the human cost of delay, and a warning that failure to act is no longer legally neutral, it is wrongful, unlawful, and unjust. But the opinion also leaves us with unfinished business. It hints at mechanisms for loss and damage, but does not construct them. It affirms equity, but leaves allocation unresolved. It acknowledges polluter pays, but stops short of enforceability. Polluter prey principle has not been identified as customary international law in the ICJ opinion. The task before us, therefore, is to carry this opinion from the halls of The Hague into the institutions of global governance, to reform compliance under the Paris Agreement, to establish climate claim commissions, to enshrine environmental rights domestically, and to ensure that justice for climate displace is not postponed indefinitely. As the court's climate obligations are no longer voluntary aspirations. They are binding duties owed to international community as a whole. Climate duty is law. Climate duty is justice. Climate duty is now. The era of climate duty has begun. Let us not fail it. As a prelude to COP30, the ICJ advisory opinion is Ordem e Progresso. In Portuguese, it means order and progress, which is inscribed on the flag of Brazil. Therefore, it's both order and progress, Ambassador, that we expect from COP30 at Belém. Thank you very much.
Thank you, Mr. Chima, for that overarching view on the ICJ's opinion. Rightly said, what mechanisms, what practical standards should be used to assess whether a state has met its due diligence? I think this is something that we can, unpack later. But now I request Ms. Urmi Goswami to please share her remarks. Ma'am, whatever you're comfortable with, if you'd like to take the podium.
Always a thing to follow a tall person. Right? First adjust the mics. Good evening, and I want to thank Mobius Foundation for inviting me. I must say I feel a little out of depth already. I'm in a panel with eminent lawyers, jurists, and I don't even have a law degree to my name. Mercifully, I haven't fallen foul of the courts, so my relationship with the courts are okay. So for me, and as I was hearing you, I was going and having heard many other, when I was writing, as a journalist, my job is to write this complex and multi-layered advisory into something that is easily digestible. And as you were speaking, it actually threw me back to the same evening of the 23rd of July, where I felt as much out of depth as I now realize I am, because this is an opinion which is still being unpacked, as you rightly said, and perhaps that is why we hear so little of it in the run-up to COP30, or it's odd because as we are speaking today, Brazil's President Lula and UN Secretary General Antonio Guterres are getting ready. If they're awake, I presume they're already awake. It's morning in New York, getting ready to host a climate leaders summit. And one of the things on the agenda is to get countries to announce their new NDCs or nationally determined contribution. And if you're thinking, and as we are sitting here talking about the ICJ advisory opinion, what becomes very clear is that the NDCs are not just domestic expressions of what climate action countries will take, which they are, but they're also circumscribed in a larger collective endeavor, which the advisory opinion makes very clear. So this journey we have been on for the last 10 years with the Paris Agreement, which has constantly sort of reiterated the national nature of of climate actions. Actually, what the ICJ advisory does is say, yes, it is, but it is not in a vacuum. There is a larger overarching sort of collaborative conversation that needs to happen, and an obligation that exists. So it's not enough to say that I'm going to do this much. There is a relationship with the global obligation. And it's interesting that we're having these two conversations on two ends of the earth, so to speak. And let's see how it goes. But it's perhaps because this advisory opinion is so complex that we don't see so much reference to it in all the conversations that are happening in the run up to COP30. And I think the other thing that struck me listening to you was the ICJ advisory is also a bit like the Paris Agreement. So there is something in it for everybody. And perhaps that's why, because there is something in it for everybody, and yet there are, in a not always necessarily in a positive way. So therefore, it's almost like a conspiracy of let's not talk about this till the lawyers have sorted it out, kind of a thing. So, from a journalist perspective, from a lay person's perspective, somebody has been writing on climate change, covering negotiations. What does the ICJ advisory opinion hold for me? Why do I write about it as a seminal moment? Many of the things have already been stated. Much of it you may have read before coming here, when it was unfolding in real time. But some of the things do deserve a reiteration, so I'll quickly run through them and then point out a couple of things that I think still remain interesting, which you have alluded to actually, but I'll do it in a layperson way. So correct. So my apologies to all lawyers. If I get the law wrong, please, sorry. Now, one of the things why, to me, why this advisory opinion was so important is that it puts science right in the middle of the legal framework. They're not two separate things happening, so they are not parallel universe, they are in the same universe. And what does that mean? At one level, it also means that it's Durga Puja time, and there were cloudbursts in Calcutta. Calcutta is flooded, which basically means that's almost paid to the pujo. But what does it mean? It means that this act of nature, the state cannot walk away from it by saying it's an act of nature. It has a moral obligation. It has a legal obligation. It's not just a moral obligation, because because science and the law science is situated in the legal obligation. So the science gets a space of primacy, and that to me is the big thing in this. Big thing for me as somebody who writes on this subject when it comes to looking at this advisory. Of course, the other thing is the obligation of states. It is not just a nice thing to do, it's an obligation. It's also what is also interesting is that states are responsible for actions not just of itself but of its consequences, private sector, citizen groups. So basically, the state has a responsibility to act and take action. The what I find interesting with these two things uh, is that. Uh, it almost feels like governments around the world are still playing catch up, or because it's an advisory opinion and they haven't yet turned up in sort of cases. Climate change cases haven't turned up in courts for hearing, or are still in the process of being deliberated. uh, we are still not seeing the advisory become something real for governments, and hence the lag. But it would be interesting as more cases come up and the advisory exists, how it becomes the sort of a guide or a reference point for judges as they adjudicate cases. Uh, of course, while we have been talking about the obligation of action, the legal obligation of action, there is, on the other hand, the legal obligation of support. Again, very a critical, important question as we move towards COP30 in Belém, because that's the other side of the story. We keep talking about NDC and action, and on the other hand, is how do you have more countries, especially developing countries, do more and faster without the kind of support that has been missing. Again, the support, not really funny, but the odd thing in the Paris Agreement is we talk in terms of contributions, and we talk in terms of contributions in terms of NDCs, but also on the finance side. And the fact is, these are not contributions, have a voluntary nature, sort of appeal to it, which is obviously how it got negotiated to give that thing. But what the ICJ tells you, that you may think it's voluntary, but it's not. You have a legal duty. Uh, in this legal duty also comes, as I was saying earlier, not just actions you're directly responsible for, but indirect action, not just of the private sector, even the kind of subsidies that are given to fossil fuels by states, by governments. That too is something that comes under its ambit. So in a sense, what the ICJ opinion does is, at one level, it goes through all the things that people have been asking for clarity in terms of what you're responsible for, what your obligations are. That's great. On the other side is the big political question that unfortunately has not got resolved in virtually the entire career of climate agreements, and that is the question of differentiation between developed and developing states. Now, the advisory opinion does sort of, again, refer to and embed the principle of common but differentiated responsibility and respective capabilities, and also with the Paris Agreement addendum in light of national circumstances. But the fact is that, again, there is no real clarity as to where. I mean, while there is common but differentiated responsibility, the differentiation between states is not. That's a question that has left unanswered, and that's basically one big political problem that unfortunately has bedeviled all the negotiations, and I presume will continue to, because once you start, because what needs to be resolved there is also the issue of fair share, and how do you turn. Yes, you have responsibility of action, but what is your fair share of your. Those things have remained unresolved, and I presume those can come up as national jurisdictions sort of cases come up. But that is obviously my question: is how do we resolve that question in a legal framework given in drawing from this advisory opinion. But that's something all the lawyers in the room and the panel can respond to. Uh, but there is another bit there which is interesting for countries like India and Brazil, and that is there is a understanding that the common but differentiated responsibilities is not a static concept. Again, we are not, again, there is no clarity where, how do you stagger this, because we haven't had a conversation on fair shares, and that to my mind remains one of the big gaps of the advisory opinion, because in a sense that whole question of who is responsible and who has the obligation to act is what drove this student project to this big thing at the International Court of Justice. And yet I think somehow that main central question still remains partially unanswered. What has happened instead is how it has got linked, like the Paris Agreement itself does, link itself through all of society, all of government approach. It also links, the advisory opinion has also linked through all other sort of not just climate laws but related environmental laws and of course customary law. So that again, in a sense, and positions it in human rights. So in a sense, it kind of mirrors what countries agreed to do, which is take it from like a cocooned sort of climate approach to an all of government, all of society approach. So this actually gives a legal legs to that. But then, as I said, for me as a journalist writing like India, Brazil, South Africa, actually even China, what happens? What is their obligation? How do we measure those obligations? How do we ensure? What is the mechanism for ensuring that these obligations are actually met? It is one thing to say in law that this is not a choice, but how can we take it to its logical conclusion? Yes, I while I think that the advisory opinion should frame a lot of the conversation in the run-up to COP30. It is not, but perhaps the reason for it is because the last chapter on this opinion has yet to be written. Thank you so much.
Thank you, Ms. Survi. So, for someone who really covers climate change and environmental issues, we do see this opinion shaping public debate, or political will for the foreseeable future. And what it certainly does is, I think it creates a narrative around climate responsibility. It has certainly initiated that. So, thank you for your remarks. I'd now like to invite Professor Narinder Singh for his remarks. So, you may be seated, or if you'd like to come over.
Chairman of the Mobius Foundation, Justice was the Chairman of the National Green Tribunal, Excellency the Ambassador of Brazil, Mr. Chima, and distinguished participants. I thank the organizers for inviting me to share some thoughts on the recent advisory opinion on what the court has recognized as an existential threat. That is the threat posed by climate change, and especially the rapidity at which the climate change is occurring. Now, two questions were posed to the court as to, firstly, the obligation of states under international law
to ensure the protection of the climate system and other parts of the environment from the anthropogenic emissions of greenhouse gases. And secondly, the legal consequences under these obligations, when they, by their acts and or omissions, have caused significant harm. It is significant that the ICJ has given a unanimous opinion. Out of 29 advisory opinions which the ICJ has delivered so far, this is only the 5th time that the members of the court have reached unanimity on the opinion. However, this does not mean that there is complete unanimity or complete agreement among the judges, because a number of them have given separate opinions, separate declarations, in which they have raised issues that they felt either had not been adequately covered under the opinion, or which they felt should have been treated differently. The most important aspect of the opinion is the emphasis on the relevance of science to the climate change issues. And for this, the ICJ has identified the Intergovernmental Panel on Climate Change as the scientific body which is the best suited for advising on climate mitigation actions. Now, the Paris Convention, the Paris Agreement on climate, the Framework Convention on Climate Change refer to keeping global warming below 2 degrees centigrade, but felt that it should be even below that. The IPCC has suggested that 1.5 degrees, and the states parties to the meetings have also gradually come to agree on the figure of maintaining the global rise in temperatures of above the pre-industrial era to a level of 1.5 degrees centigrade. This the court considers as amounting to a subsequent agreement between the parties, and therefore applying the rules of interpretation under the Vienna Convention on the Law of Treaties. The court said that this is now the limit which is to be aspired to. And this is also a limit endorsed by the IPCC, which has stated that for every increase above 1.5, the incremental efforts which would be required to contain it would go up immensely. And therefore, maintaining this level is very important. Now, ever since the UN was established, the UN and its agencies have been engaged in negotiating and adopting a wide range of international treaties and conventions relating to different aspects of environmental protection. Most active have been the conventions on oil pollution, whether it is oil pollution from ships or damage from the oil platforms, etc. Conventions have been adopted to limit the damage and also to provide compensation. And an international oil pollution compensation fund has been in existence for a long time. In 1992, at a major conference under the heading Agenda 21, the UN adopted 3 conventions. That is the Framework Convention on Climate Change, the Convention to Combat Desertification, and the Convention on Biodiversity. So these are the 3 major conventions which are cited as the law on climate change. Before the ICJ, some states had argued that these were a special law and therefore they displaced other rules of international law in the global effort to respond to climate change. The ICJ did not accept this view. As Mr. Chima had just mentioned, the ICJ referred to the work of the International Law Commission, according to which the lex specialis could displace the lex generalis only if, firstly, there was a conflict between them, or if the lex specialis had actually contemplated substituting the rules under the general law. And they found that in this case, there was no conflict between the climate treaties and the earlier rules of international law, or the customary rules of international law. And therefore, this held that both will apply and they must be interpreted in a manner to give effect to all of them, both the customary law as well as the special treaties on the environment. Now, coming to the rules under the Paris Convention, the court went into detail in the various steps that states were required to take, especially in the NDCs, that is, the National Declarations of Commitments, which are to be renewed at periodic intervals. So the court firstly laid down some standards for the NDCs, that these have to be not a mere statement of vague objectives, but there must be specific actions, and they should be aspirational. That is, every successive NDC must aspire to a higher level of action to combat damage to the climate or to combating climate change. And this was held to be both an obligation of conduct and an obligation of result. So it is not merely to adopt those programs, but to work consistently to attaining the objectives set out in the program. Apart from this, the convention also has the obligation of adaptation. That is, to adapt to climate changes. And here also, the court emphasized the duty to cooperate with developing countries and those who are in need of assistance, so that all states can work together to find solutions for adapting to climate change issues. And this was held to be an obligation of conduct, not a result, but the conduct must be one of a best effort and efforts taken in good faith to achieve the desired results. The court also referred to other principles of international law, including the customary rules, and decided that these rules apply to all states, irrespective of whether they are parties to the climate treaties or not. And states could be held liable for breaches of those obligations. In the case of customary international law, they owed a duty to all states to take effective action under that law to address climate issues. In the case of treaties or conventions, the states parties were responsible to other states members or states parties to the treaty and answerable to them for any lack of implementation or any lack of taking action to carry out their obligations. The court also went into detail into the Law of the Sea Convention, which requires states to take effective measures to prevent and combat and reduce marine pollution. But the Law of the Sea Convention itself highlights that this obligation is based on the capability of states and the availability of scientific and technical knowledge to them. And so the developing countries have an obligation, have a best effort obligation, whereas other industrialized or developed countries have a higher level of obligation to prevent and reduce marine pollution. The issue of marine pollution will acquire greater significance because of the likelihood of deep sea mining taking place in the near future. Although the Law of the Sea Convention was adopted in 1982, that is more than 40 years ago, seabed mining is still not a reality for various reasons. Firstly, because the minerals which we were expecting to mine from the sea due to shortages on land, those materials still continue to be available in sufficient quantities on land. So the need for sea-based minerals did not arise, and companies have not made investments in the necessary technologies. Secondly, maritime boundaries are still being negotiated, and until a clear picture emerges, especially where the deep sea were concerns, countries are waiting for that. Again, prices of those commodities did not go up to the extent which was anticipated. And in the meantime, substitutes have been found. Like copper has largely been replaced by cable fibers. And so the demand is not there any longer. Okay. So, another aspect which was highlighted was the common and differentiated responsibilities, and also the issue of development. Because a large number of poor countries and underdeveloped countries still need access to the minerals and other resources for the development of their peoples. And this is an issue which has also been highlighted in the Sustainable Development Goals adopted in 2015. And a number of those Sustainable Development Goals are very relevant for the climate change. Even though climate change is directly referred to in one of them, the sustainable development of a forest reserves, the land minerals, and even the seabed issues, and especially highlighting cooperation among countries. These have found a very important place in the Sustainable Development Goals. Thank you.
Thank you, Professor Narinder Singh, for your insights. I wonder if we are headed toward the ecocide in that direction, with the idea of criminal liability. Now, I would request Honorable Justice Prakash Srivastava to please share your remarks, sir. We've been eagerly awaiting, and you may please comfortably sit there and share your remarks, sir. Okay, sir.
Justice Benjamin, Chief Justice of Supreme Court of Brazil, who has joined us virtually by sending his address to us. Dr. Barman, Chairman of the Mobius Foundation. His Excellency, the Ambassador of Brazil, eminent panelists, Professor Naren Singh, Ms. Urmi Goswami, and Advocate Jitendra Jayachima, and all the dignitaries who are present in this gathering. It's very inspiring that majority of the presence here is of the students. And I would like to go to their level so that my message is conveyed to them. The discussion, as has been said, that this relates to a very important topic which is being discussed everywhere in this planet, that is the climate change. That too in reference to the advisory opinion which has been given by the International Court of Justice, clarifying the responsibilities of the states, their obligations, and what they are expected to do. This advisory opinion is not a mere academic discussion. It's not a theoretical abstract. It is an opinion given by the highest judicial body, and that too after deliberating upon various treaties which have been signed in the course of time, after examining the customary international law, the obligations which the states have, after applying the various principles, and then setting down the obligations, responsibilities of the state towards the climate protection. Now, what was the need for the UN to go to seek the advisory opinion of the International Court of Justice? Entire world is witnessing the extreme weather events, the rising global temperature, the rising greenhouse gas effect, cloudbursts, melting of glaciers, bursting of glacial lakes, rising sea level. So all these were the issues which the planet was faced with, and at the same time, there was a wide gap between what the states were expected to do and what the states were actually doing at the ground level. So this was the need why the UN General Assembly approached the International Court of Justice for seeking its opinion on two issues. Now, the International Court of Justice has considered the agreements such as UN Climate Change Convention, the Kyoto Protocol, Paris Agreement, and it has, in a way, when the opinion was sought by the UN General Assembly, it has given a background reflecting that the burden of the climate change is borne, the worst affected are the marginalized people, women, children, indigenous population. And in this background, narrating these facts, the opinion was sought. The two questions, as it already has been pointed out, first was, what obligations do states have under international law to protect the climate system for present and future generation? And the second question was, what are the legal consequences if states cause significant harm, whether by their action or inaction, failure to take action? Now, when these questions were posed to the International Court of Justice, first they examined their own power to give such advisory opinion. They looked into Article 65 of their statute. Then they considered Article 96 of UN Charter. And they found that yes, they have the power to give such kind of advisory opinion. But then the next question was their discretion. It was not necessary, even the power is there to give such kind of advisory opinion. So they again examined it, said no. This is a case where we should not deny the advisory opinion. So they went further. They examined the international treaties. They relied upon the UN Charter, UN climate treaties, law of sea, biodiversity conventions, desertification convention, ozone and Montreal Protocol. And they took the view that these treaties, they don't exist in isolation. They coexist with the customary international law. And the obligations which the states have, those are not static. With the advancement of science, with the change of capacity, with the development, those obligations also change. Then they reaffirmed the two fundamental principles of customary international law. First, the duty to prevent significant transboundary harm and the duty to cooperate. And they tied these two principles with the human rights. Because right to clean air, water, sustainable environment, they are all binding part of the international law. They stressed on one thing, that without environmental protection, the other rights, right to a dignified life, those rights cannot be protected or ensured. Then what does it mean in practice? That means the states must prepare, maintain, and implement their nationally determined contributions under the Paris Agreement. They have in fact, they said these are the obligations of result. Then they said the obligation of conduct. The domestic measures which the state should adopt to achieve these objects with due diligence, that is their obligation of conduct. And the object is to achieve or cap the global rise in the global temperature to 1.5 degree, which was existing in the pre-industrial era. And Then they emphasized on the issue of cooperation concerning cooperation between the countries on the technology, science, financial cooperation, so that this goal can be achieved. Now, this climate change issue is a diffused issue. You can't pinpoint, yes, this is the area from which is the cause of the climate change, or this is what is emitting the greenhouse gas. So there is a difficulty in fixing the responsibility. Therefore, the court says no. The individual polluter is not required to be identified. If the state knows that the harm is likely and the conduct of the state has materially contributed or is likely to contribute to that harm, then the responsibility of the state arises. The court therefore stressed that these obligations are erga omnes, that is, towards all the nations. Then the entire thread of this opinion of the International Court of Justice that surrounds around the human right issue. All the treaties, everything is connected to the human right. And it has reminded that the human rights concerning the security of food, drinking water, safe housing, everything depends upon a stable climate. And no state can claim that its responsibility ends on the border of the state, because the emissions have the transborder effects. And then it went further, the ICJ went further and examined what is the consequence of the state's failure to act. Therefore, they said that the responsibility arises from both action to prevent the emission of greenhouse gases, and omission. The impact of the opinion, if we see, the greatest impact is now we are discussing it. The governments, they are now re-examining their policies, considering the factors which have been reflected in. The courts are now in the process of taking help of the reasoning which has been given by the ICJ in the opinion while deciding the cases. The subsidies for fossil fuel, they are under review. The corporations, the big houses, they are facing the pressure to disclose the climate risk. The investors are now recalculating the value of carbon heavy assets. So it's a landmark judgment, landmark opinion which has been given. And if we look at it, if we compare it with the views the courts of other jurisdictions were expressing in the climate issue, we'll find that it aligns with that. Like in the case of Agenda Foundation versus Netherlands, the citizens had approached the court raising the grievance about inadequate climate measures. And the Supreme Court there had held that failure to cut emissions violate human rights obligation. In Neobior's case, the young petitioners had contested the deferred climate action, and the constitutional court there had held that postponing mitigation violate intergenerational equity, and they had ordered stronger measures for the climate protection. In Switzerland, in the case of Clemens Senyorinen, the elderly women, the widows there, they had approached the court, raising a grievance against the heat waves, saying that their private life, their life is affected because of that. And the court came to their rescue, saying that the inadequate climate action is their right to private family life. So this is the view which the international courts were taking, and the view of the opinion which is expressed by the International Court of Justice aligns with that. If we look at the views of the Indian courts or the Indian jurisprudence in this regard, in our country also the view of the court is that climate justice is a part of Article 21 of the Constitution. The three principles which the International Court of Justice has discussed in the opinion, that is polluter pays principle, sustainable development principle, and precautionary principle. These are the principles which the courts, especially the National Green Tribunal, applies every day in its orders. If you look at the Indian judgments, look at the case of MC Mehta versus Kamal Nath, where the court has held that the natural resources are held as a public trust by the state, and they cannot be diverted for the private use. In T.N. Godavarman case, the Supreme Court is focusing upon the prevention of tree felling, preservation of the forests. That is for the purpose of sustaining the life in the planet. Recently in M.K. Ranjit Singh, the Supreme Court has held that a fundamental right against, they have recognized in fact the fundamental right against the adverse effect of climate change to be rooted in Article 14 and 21 of the Constitution. So in fact, what the International Court of Justice has opined, that's the same line which the courts in India are proceeding with. Now, like any other judgment of the court, the opinion which has been given by the International Court of Justice has also been criticized. One criticism is there's a long essay which only discusses the treaties and the obligation under the treaties. But what new has been said? That's one criticism. And there is some say that no, it does not provide any clear instructions. Then it is criticized on the ground that there is no binding direction issued. And if there is no political will, then what the International Court of Justice has said, and states may not follow it. Then one of the criticism is about the due diligence principle which has been mentioned, that there may be an urgent need for an action by the state, but the state may say, we did our best, we could not do anything. But as usual, the criticisms are there and will be there, but it's an opinion which has profound effect on the protection of the climate. It tells us this is the time when we should take action. And this is the generation we should take action. It reminds us the principle of intergenerational equity and then focuses on the state's obligations in this regard. So the way forward is that this opinion should be considered and acted upon in a positive manner by all the states. There should be an effort by all the states to discharge their responsibility, obligations, which have been set out in this opinion. And if it is taken in that perspective, then we are hopeful that some positive result will come forward. Thank you. Thank you very much.
Thank you so much, sir. Thank you for taking us back to the evolution of the genesis of environmental law in India, reminding us of these landmark judgments and how we're so aligned with the International Court of Justice's advisory opinion. We have time for 2 questions from the audiences. So, could you please raise your hands? And Your Lordship, will you be taking questions today? Will you be taking, or could I address it? Okay. So just 2 questions. And please make sure that it's a question and not a comment, please. We can't hear you, sir.
Good evening, sir. My name is Shubham. I am from social work background, from Delhi School of Social Work. So, sir, as you were talking about the due diligence, state due diligence. So now we are observing very practically that a state is becoming very rigid, sir. There is no boundary between public sector and private sector. Even private sector is private property is also becoming private company limited. The word growth and development, there is no any differences. Those who are cutting 10 lakh trees, they are stating that I am doing it for development. So why not we should give some real definition of development? This is my, what should be your take on these things?
Who are you addressing your question to?
Right. Yeah, right.
Mr. Chima.
Okay, before I answer that question, only day before yesterday, our Honorable Supreme Court, Justice Vikram Nath's bench has passed an order, okay, actually taking up what's happening in Himachal Pradesh. You know, year after year, please be seated. You know, year after year, we see that this devastation is happening in that hill state. You're also finding a similar thing in Uttarakhand. So he has passed an order where, you know, he has posed questionnaire to the government of Himachal Pradesh, which they need to respond by 28th of October next month, when the next date of hearing is. So I think, insofar as courts are concerned, they are taking a very structured approach to this whole issue in terms of how it should go about. You know, there's it's very interesting to read that questionnaire because the 8-page questionnaire written by the amicus and being given to the state government that they need to respond to these parameters. And climate is one of the issues which has been discussed in that. My point is that basically all policies need to be aligned. Our jurisprudence, our policy and our law has to be in tandem. Okay? Without that, the real change will not happen. Anybody else wants to respond?
May I add in this? You said that the project proponents, they are cutting the trees and they say that they are doing it for the development purpose. This is where the question of balance comes in. And this is what the sustainable development is. Nobody says that you protect the climate at the cost of development. And nobody says that you carry out the development at the cost of climate. So the balance is required to be struck. In the practical sense, if you cut the trees, if you cut 100 trees, plant 1,000 trees, right?
There's just one thing I wanted to say, and to just bring it back to the entire discussion that we had before. The whole idea of climate action and action for growth or development. There are trade-offs, but more importantly, I think we have now to be in a place where we move from the conversation of trade-offs to assessing risk. What is the risk of doing X, and what is the risk of doing Y? There is it's not about questioning whether or not we need development, and I think it's in addressing the question of risk, which of course can be done in different ways, and both two options have been sort of two perspectives have been put in that. Is that you will have your answer of what is development and growth. There is no unitary, uniform answer. It is about risk. The people who have built the roads in Himachal, and whether it's government, it is government, companies, even habitations, did not do so with the knowledge, with the desire to have this catastrophe. Yes, there were people who said this would happen. Yes, they said this is not the way to do it. That risk, what is the risk of taking an action? That is what will define what is growth and what is development. Thank you.
Last question. So can we please maybe give the student an opportunity to ask a question? Sorry, sir. Would you?
All right. Firstly, my excuse, I'm not a student. I'm a law professor.
Oh, my apologies then.
So yeah. So my apologies to sir. If you may allow, then maybe he may add to the question. I'll just be very short with that. My question, which is this whole discussion reminds me of 1996 advisory opinion as to nuclear and the threat of nuclear weapons, wherein most of the discourse is related to the controversial aspect of whether or not nuclear technology and the weapon is legal and the threat of that. But then there was an aspect of the WTO's intervention, wherein the damages to the climate that the nuclear weapons could do was also deliberated in the ICJ's opinion. It was one of the founding moments wherein the ICJ would dwell upon these aspects and reiterate unanimously as to that there is a climate obligation that the countries must respect.
So what's your question?
As to that, sir, for fast forward 2025, the climate aspects have always been with regard to the difference as to the north and the south and how they take it. There has not been the binding opinion in 1996, and there seems to be not binding opinions and lots of opinions, particularly with no, as we would say, concrete actions in that opinions. So how do you take it? And I am reminded of Professor Chimney when he said that there is always.
So I have to cut you short.
Okay.
What is your question? If you could.
Sir, how the courts is to take these opinions in the Indian courts context, particularly when there are aspects of poverty that is involved. When we discuss climate litigation, there is also the impacts on the poor and the like.
So I think
Yes.
these are remarks, comments, or.
No, I'm just interested as to Professor Justice Srivastava, how he does look into and what is the process of you delivering as to the judgments as climate litigation and how you will deal with them. Thank you.
No, it's so far as the opinion which is given by the International Court of Justice is concerned. It has discussed the treaties. It has set the obligations, okay, the state's obligations, and it has set the binding effect of it. So the reasoning which has been given by by the International Court of Justice in this process that can very well be used by the courts. You can't say that some law has been laid down because it's an opinion. So the court is not required to give any direction, but they have discussed it, they have elaborated the principles, they have given the binding effect. So the courts can always use it, and in fact, they'll be using it. The reasoning which is given in the opinion that will be used by the courts in their judgments.
May I just add to this? You see this advisory opinion, lot of people have this, that it's an advisory opinion and it's not binding. Okay. This, how has it come about? Your Lordship had alluded to it in his speech. You see, the UN General Assembly actually passed a unanimous resolution and said that we should reach out to the International Court of Justice for an advisory opinion. Who are the members of the General Assembly? All 100 and 200 plus member states. Okay, so there's a resolution which was passed. It was sent to the ICJ president to render that opinion. Okay. Now coming to the North-South question, I think very important question for the South, global South, which has been enshrined in this opinion. I think all parties who have enunciated that principle in this advisory opinion, in their written submissions, deserve all the kudos. Okay, what is that principle? So, what is, as the chairperson had said, what is this opinion? It says what is the applicable law. It actually defines what is an applicable law as far as climate law is concerned. Okay, it has recognized law. It has enunciated principle. Common but differentiated approach. This was a principle which emanated out of Paris Agreement. But this fundamental principle has now been recognized as applicable law in the ICJ judgment. This is a big achievement for a global South. So I think you have to really split it. As I think the last word is not out as yet. I think this will go on for some time. But I think there's a lot of material there which will set you thinking as to how you can use that jurisprudence in your domestic courts.
So,
As a matter of fact, can I just make one more point? I was on a call 2 hours before I came for this dialogue today. And I can't tell you which country is going to sue which country under the new ICJ opinion. There is already now talks about smaller island states looking to litigate, take bigger neighboring states which are polluting to the ICJ. So there is already all this happening. It's not something in the far future. This is going to be unraveling over the next course. I mean, this is where the next set of jurisprudence will happen.
thank you, Mr. Chima. So we're very cognizant of the time. My apologies, sir. Okay, sir, sure.
It's true that this opinion is an advisory opinion, and in technical terms, it is not binding on states. But the important thing to remember about any advisory opinion from the ICJ is that this is a pronouncement of the principal judicial organ of the United Nations. And whatever opinions the court gives, they carry a lot of weight. And they influence states' actions and thinking in the years to come. So even though they're not formally binding, this is the authoritative interpretation of the relevant conventions, of the relevant law, and this will be cited by states in all their interactions.
Absolutely. Thank you, sir. Now, to conclude the evening, I invite Mr. Praveen Garg, President of the Mobius Foundation, to deliver the vote of thanks and then to facilitate our esteemed panelists and distinguished guests, including our His Excellency, Ambassador Kenneth.
A very good evening to all ladies and gentlemen. Honorable Mr. Justice Prakash Vasaji, we are deeply grateful for your presence and for the wisdom you bring in. Honorable Chief Justice Antino Benjamin, Thank you, sir, for your inspiring video message. I sincerely hope that this exchange between two leading voices of the global South, Brazil and India, will continue to grow into a meaningful partnership for the future. My special thanks also to the Ambassador of Brazil to India, His Excellency Mr. Kenneth Excellency de Nobrega. I hope I pronounced it correctly. And to each of the distinguished speakers who have joined us on this platform today. Your time, insights, and experience enrich this discussion and make it truly a collective effort. I would also like to acknowledge and thank Chairman of the Mobius Foundation, Mr. P. Burnham, for his steadfast commitment to environmental reforms, for his immense contribution to advancing sustainable transition. His leadership continues to remind us that humans and nature are inextricably connected and must thrive together. At Mobius Foundation, our think tank is guided by the principles of research-led action. We firmly believe that knowledge must precede action and that a careful balance between deep thinking and decisive implementation is essential for meaningful progress. In this spirit, we have been actively conducting research across multiple domains of environmental importance: climate finance, sustainable infrastructure, environmental law, biodiversity conservation, and governance. We are also working now in partnership with NITI Aayog to strengthen the emerging framework for extended producers' responsibility (EPR) across 8 sectors. This is a crucial area as it directly addresses the challenge of managing the life cycle of products and reducing the burden of waste on our ecosystems. Through such initiatives, we aspire to contribute meaningfully to building systems that are sustainable, circular, and equitable. This platform, Advocating Change, was created to explore emerging developments in the environmental and climate law. Our objectives have been to raise awareness, foster dialogue, and provide a stage where diverse stakeholders can contribute intellectually to the growing global conversation on environmental challenges. This is the second event in the series. The first was held in 2024 and it was on climate, liability, justice, and jurisprudence. As it was being mentioned, it came out of the case versus the state, especially on the renewable energy in Rajasthan. Intellectually and scientifically, we are witnessing a shift towards a multidimensional frameworks that better capture the complexities of anthropogenic impact on environment. The United Nations has characterized this as triple planetary crisis: climate change, biodiversity loss, and pollution. Building on this perspective, Mobius has embraced the concept of planetary boundaries, pioneered by Professor Johan Rockström and his colleagues at Stockholm Resilience Center. According to a study published in Science Advances in 2023, 6 of these 9, I repeat, 6 of these 9 planetary boundaries have already been reached due to anthropogenic activities. This means that Earth is moving outside the safe operating space for humanity, and the risks of irreversible change are mounting. Realizing the critical nature of this moment, we at Mobius felt compelled to act because action is required. To this end, we commissioned a 10-episode documentary television series based on planetary boundaries. Our 10th episode is on population. It is very close to our chairman's heart because in the background, it is all a huge population, especially in India, which is affecting all the spaces, whether it's urban or rural. We are doing it in collaboration with Warner Brothers Discovery. This series explores the planetary boundaries that are most at risk in Indian context, while also highlighting the positive steps that individuals, institutions, and communities can take to restore balance. I'm happy to also share that while filming, and it's nearly completed, we saw a lot of good work at the individual level, at the community level. It can be scaled up. So it has a hope. Of course, there's a crisis, then there's a hope. And we should be launching it by Christmas. And in this also, we are saying call for action, call to action. So we'll recognize people who have done wonderful work and who are looking for little funds which we can provide to them to continue, or if it can be scaled up. It is our aspiration that this work will not only educate, but also inspire action. The scale of distraction we are facing is daunting. It is planetary in scope. It compels us to rethink our relationship with nature. But alongside this fear, there is also hope. This landmark advisory from International Court of Justice signals that the world is awakening to a new reality. The safeguarding the environment is no longer optional, but fundamental. Our public institutions, our legal systems, and our collective imagination must now place nature and sustainability at the very heart of our mission, or their mission. I would also like to acknowledge the presence of youth, students from the institutions such as Maharaja Agdusen Institute of Management Studies, MIT University, Delhi University, Vidya University, Guru Gobind Singh University, Niti Aayog, Random House, and many others whom I may not have mentioned here, but who are present here. But I would say this conference, this talk, is meant for youth. Because, of course, many of us will pass away, it's a matter of time. It is you who have to face these planetary challenges and these breaking boundaries in the time. So the action is required, and the hope lies, of course, in all the generations, but more in the youth. Let us continue this journey together with clarity, with courage. We need courage to act, and with compassion, with Corona, for planet we call home. Thank you so much for being here.
Can I, Mr. Berman, can I please invite you on stage to felicitate our guests? you. Thank you so much. We now request our distinguished guests to please join us for dinner. Thank you.